released you on the outside?
I believe so.
Was that what they told you?
Yeah, I think so. They told me it would be the last time they see me in jail, but you know.
Okay, all right. All right, so here's what we're going to do. I am putting you on the 36 months probation. You only have to serve half of that if things go well. And I'm just gonna make a note here that if you can get this all paid off and stabilize yourself, you can even get off earlier, because I think that your rehabilitation has started. I don't wanna waste a lot of time once you get stabilized, but I do need you to pay back this money, and it is a lot of money. It's going to take you some time. But they can also get rid of the conditions of probation with the exception of holding a job and making payment if everything else is completed. So there's a compromise for you, okay? I'm not going to charge you any probation oversight fees. The money needs to go to pay the restitution. However, you are going to spend 365 days jail with credit for the 223. When you have stable housing that you can be transitioned into through RISE or any other agency, so you have a stable address with services in place, then you can be released from jail and the balance will be held. I'm not releasing you into the winter snow. You'll go from jail to housing.
Believe there was housing already.
Great, then you won't spend much time in jail. That's what I'm saying. I don't want them to transition you out onto the streets. There's a waiting list for housing. So if we can get you as a priority from the jail to housing, that's what we're gonna do.
So Your Honor, you're putting on after 365 days?
No, not after. Within the next, as soon as there's a bed, a house, as soon as he has actual housing, not a shelter,
Okay.
then we're gonna hold the rest in abeyance. Okay,
Okay, so
does that make sense to you, sir?
It makes sense.
Okay, so if RISE already has a stable place for you to live, that's where you'll be. Okay, so you'll be released. If it's gonna take them another week, then you'll go in a week, okay? I don't wanna release you to a shelter. I don't know that there's beds. I don't want your fingers and toes cut off. It's nasty out there.
yes, okay, so yeah, when you go back, you do your planned intake, and if they have a bed for you, and they'll get released.
Okay?
This week.
Until you are released, you'll continue with CATS and working with community mental health. Once you are released, then you'll have 48 hours to report to probation. Usually it's 24, but because of the circumstances, I'm giving you 48 hours to report to probation. And then you will continue your work with community mental health, RISE. You'll be part of a work seek program. I understand you've got some issues going on. Have you thought about, are you applying for SSI or SSD or any of that?
Yeah, I will be once I can.
Okay, so you will pursue that, and then in terms of working and supporting yourself, you'll follow whatever those rules are. You will pay restitution to Lansing Catholic High School in the amount of $15,907.58, and also Clarion Point Hotel. And the breakdown of that, I believe the people have already put on the record. Now, counsel, one of the things that you might want to check, because there's no such thing as a double recovery. I suspect Lansing Catholic High School has insurance, and maybe the insurance covered it. So the money may end up going to the insurance company if they're interested in having that repaid. I think there's some other stuff going on here. I suspect the Clarion Point Hotel too has insurance. So while they're due restitution, if they have other sources to be paid, they're only due one restitution, not two. So if you could help figure that out or pass that on to community mental health or probation, whoever he's working with, that would help, and that would shorten his probation. Does that make sense to you, sir?
Yes.
You'll not violate the laws of the state or any other. You'll not leave the state without permission of this court. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You will comply with alcohol and drug testing, and not adulterate any of those tests. And sir, I don't know if probation, showing up at probation, if they'll do that for free for you. It doesn't look like you have a huge alcohol or drug problem. I don't know. But those tests can get expensive. So unless we have a positive, I'm not going to require regular testing. But if there is a positive, we will have that verified by a subsequent test to make sure what it's positive for. You'll have to give us copies of any prescriptions so we know if that triggers a positive, what you're on. So make sure you work with probation on all of that. You'll take any psychotropic medications as labeled on the bottle. If you're referred for substance abuse, psychological, or other evaluations, you will comply with that, sign all necessary releases so that probation can verify that you're doing what you need to do and following all recommendations. Sounds to me like you completed cognitive behavioral. Did you do that through CATS?
I have, yes.
You have, all right, so I'm requiring cognitive behavioral, but I'm going to note that it's been completed through CATS. You will not have verbal, written, electronic, or physical contact with Lansing Catholic High School or with the Clarion Point Hotel. Will not be within 500 feet of either of those places of employment. You'll be able court orders and recommendations of probation. Those become orders of this court. You'll not engage in any assault or abusive, threatening, or intimidating behavior. And you will not have any verbal, written, electronic, or physical contact with anyone who's housed in the Michigan Department of Corrections or who is a known felon without permission of this court. You must submit to a search of your person and property, including but not limited to your vehicle, residence, computer, and cell phone. Without a warrant of probation as reasonable, possibly you have items that might violate the conditions of your probation. You must report any arrest, police contact, loss of employment, change of residence or phone to probation within 24 hours. Weekends and holidays are accepted. So if something happens on a Friday, tell us on Monday. If Monday's a holiday, tell us on Tuesday. You will make genuine efforts to find and maintain legitimate employment. And if you're applying for SSI or SSD, you'll comply, as I said earlier, with those requirements, and you'll follow through with all paperwork. If for some reason you're turned down, you'll work a minimum of 30 hours per week. If you are a full-time student, you'll work a minimum of 18 hours per week. And you'll not give any employer any cause to terminate you. You'll pay crime victims assessment amount of $130 and the state cost amount of $68. That will be paid after probation. After restitution. There'll be no probation oversight. You'll comply with DNA testing unless it's already on file and unless they have already done that. I'm waiving any costs associated with that. He's not able to pay. I'm waiving any other costs, including attorney fees. He is indigent. You will not use any object as a weapon. You'll not own, use, have in your possession or under control, your control any weapon, ammunition, imitation of a weapon. If you have the need to use marijuana or alcohol, you will first get a prescription and then only use it as prescribed. You have 42 days to appeal and to request appellate counsel.
Good job, Yellow.
Is there anything,
Where? Oh, I'm sorry.
is there anything I've told you to do you think you can't do? Sure.
Oh, no,
All right. So you can be released early if you pay off everything, and if everything is completed, you can certainly just be monitored on probation, payment of restitution. Do you acknowledge receiving your appellate rights?
I acknowledge.
All right. Good luck to you, sir.
Thank you.
Please keep open communication. Let us know if there's a problem before there's a problem, okay?
I will.
This is really meant to help you, stabilize you, and rehabilitate you, okay? Good
Yes.
luck to you, sir.
Yes.
Tell me to get released for the bed.
Next,
Seth McDonald.
Probation.
hold on. This is docket 25-3273 FH, people of the state of Michigan versus Seth McDonald. Counsel, your appearances for the record.
Good morning, Your Honor. AP Verbucks on behalf of the people of the state of Michigan.
And good morning, Your Honor. Dustin Koontz for Seth McDonald, who's here to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Raise your hand. Are you taking any medication yesterday or today? Are you supposed to be on medication? You're not on. Any sign of fever, COVID, or other illness? And you will attempt to speak with your attorney?
Yes.
And I understand this was a final criminal pretrial, however, you have decided to plead, is that correct?
Yes.
All right, and, I have, well, let me just double check here. Do you still live on, is it Dakin?
No, I actually recently moved to 826 Clyde, CLYDE Street, Lansing, or 8915.
All right, and are you employed?
Yes,
And what do you do?
I'm a tool maker.
Okay, and the offense that you're pleading to were on probation, parole, or bond conditions with another court? And are you a US citizen?
Yes,
All right, and what is the plea agreement?
Yes, Your Honor, the plea will be to an added count 3, possession of a loaded firearm in or upon a vehicle. The people have not had a chance to file the amended information, but plan on doing so after this hearing. That is a high court misdemeanor. After successful plea and sentencing, counts 1 and count 2 will be dismissed. There is a Killebrew agreement to go upfront jail at the time of sentencing, and there is an agreement to forfeit any contraband or firearms collected as a result of this incident.
All right, this sentence agreement that I was just handed that you've all signed is incorrect. It says count 2, and in fact, it's count 3, is that correct?
That is correct, Your Honor. I apologize.
Okay, I'm just going to change it on mine so I know.
And we would be dismissing count 2 as well in 2A.
In 2A, you said?
2A.
And just so the court recorder, it's on their new form, it's box 2A. It only listed count 1, but now we're adding count 2 there, and I've changed on the box 1 as to the plea, that is pleading to count 3, and on 2A, count 1 and 2 will be dismissed. Is that full fair act going to complete? You agree to change this, counsel?
Yeah, Mr. Buxton, did you mention the Killebrew?
I did
Okay,
mention the
okay.
Killebrew to know what friend jail at the time of
Okay.
sentencing.
And that's all correct.
Sir, is that full fair act going to complete? And counsel, you're waiting, reading counts 1 and 2?
Yes, Your Honor.
And so you understand that all contraband weapons, ammunition will be forfeited? Is that correct?
yes.
All right, and was the weapon, was it yours or was it somebody else who lawfully had it and then you had it in your possession?
I inherited it from my father.
Okay, and has your father passed?
Yes.
Okay, I'm sorry. So is there someone else in your family who wants to take it? Here's the thing is, if somebody lawfully has ownership rights to it, they can present that and take that.
At this point, I mean, so basically when my father passed, his things got split between me and my
I'm sorry,
siblings.
when my father passed what?
His things got split between me and my siblings, and I mean, they've kind of all, they've got what they want, so I don't mean that to sound like it sounds,
I understand.
but that's it, at the end of the day, I mean, if I have to work with him, I have to work with him.
You're happy with it being forfeited, you're okay with that? I mean, there's no sibling who lawfully has a right or entitlement or wants it, is that correct?
Correct.
Okay. Okay. And, I'm sorry, Council, you waited for reading Council 1 and 2.
Yes.
As to count 3.
Yes, Your Honor, the people of the state of Michigan versus Seth Andrew McDonald, State of Michigan, County of Hingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 3, weapons, firearm, possession of a loaded firearm in or upon a vehicle on or about January 11, 2025 at Williamston Road / East I-69 Freeway, Williamston, Michigan, 48895, Hingham County, State of Michigan. The defendant did possess in or upon a motor vehicle a loaded firearm, which was not a pistol, to wit, a firearm, contrary to MCL 750.227C. This is a high court misdemeanor that is punishable up to 2 years and or $2,500, mandatory forfeiture of weapon or device unless pneumatic gun is charged. The court shall order law enforcement to collect DNA identification profile samples before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Thank you. Sir, did you understand what was just read? So you understand count 3, possession of a loaded firearm is a high court misdemeanor punishable by 2 years,
Yes,
and there'll be forfeiture of those items as we discussed.
yes,
All right, and it looks like you signed the advice of rights form. Did you read it before you signed it?
yes,
Did you understand what you read?
yes,
And if you had any questions, was your attorney able to answer those?
yes,
Sir, as to the rights, additionally, what you're giving up is your automatic right of appeal. So if you had a bench trial or jury trial and you were unhappy, the Court of Appeals must take a look at your unhappiness. But now by pleading, you are also giving up your automatic right of appeal. If you choose to appeal anything, it's up to the Court of Appeals as to whether or not they think your issues are important, and they will only grant you the appeal that you seek if they think your issues are important and they want to take it up. Does that make sense to you, sir?
yes,
All right. As to count 3, possession of a loaded firearm, how do you plead? Did anyone force, threaten, or coerce you to plead?
No.
Anyone promise you anything that we haven't made a record of?
No.
You decided to plead after you looked at all the evidence, circumstances, had all sorts of time, whatever you needed to discuss with your attorney?
yes, Your Honor.
And you have pled of your own free will?
Yes,
And you've been satisfied with the representation of your attorney?
most definitely.
And do you understand that there's an agreement, I'm not part of that, for no further upfront jail? So if at sentencing, I violated that, if I gave you some upfront jail, I would allow you to withdraw your plea in this matter, would again go to the pretrial stage. However, if you violate the law or bond conditions between now and sentencing, I can violate that because you would have violated bond or the law and not allow you to withdraw your plea. Do you understand how that works?
Yes, Your Honor.
Other than the plea agreement, has anyone told you what I will do at sentencing?
No.
And that's because I don't know, I will make up my mind at the time of sentencing. Do you understand that?
Yes,
All right, very good. Sir, did this offense occur on or about January 11, 2025?
yes,
In the township of Wheatfield, County of Hingham, State of Michigan,
yes,
at a specific location known as East I-96 Freeway and at Williamston
Yes.
Road? And were you operating a motor vehicle or were you the passenger?
I was driving.
And was that a Ford Expedition?
Yes,
And how is it law enforcement came to stop you?
so basically, I was still in the process of moving here from West Virginia.
So, so how did law enforcement discover?
It was there,
Sure.
snowstorm, slid into a ditch. Didn't have my phone on me, so I started walking to get help. By the time that I was able to get help, somebody called a tow truck saw the truck, called state troopers.
Okay, so they were doing a safety check.
Yes,
And then did they find the, it was a revolver?
yes,
Did they find the revolver in the vehicle?
yes,
Okay, and so then when you came in contact with them, they asked
yeah,
if it was yours?
yes,
Okay, and was that revolver loaded?
yeah, yeah. it
Okay.
was.
All right, On behalf of the people,
The people are satisfied, Your Honor.
they have to be plain.
Seth, was that, so when you say revolver, that would be a pistol,
Yes.
right? And was it in the passenger compartment of the car? That is not the trunk or the hatchback? Is that a yes? I'm sorry. Can you
Yes.
speak up?
Yes.
Okay. Do you have a CPL?
No,
I'm satisfied. Your
And
Honor.
you would agree that a revolver is a dangerous weapon?
yes,
All right, very good. Or pistol, as whatever you want to call it. I have it listed as a pistol and a revolver. So,
any firearm is dangerous.
agreed, thank you. All right. Are council promises, threats, or inducements, other than those already placed on the record, on behalf of the people,
No, Your
on
Honor.
behalf of the defendant?
No, Your Honor, but if I may,
You mean,
Seth, you understand that this is called a misdemeanor, but in effect, it's a felony in just about every way other than name. Do you understand that?
Yes, I do.
basically anything over a year, it goes under the sort of felony route.
So,
Okay,
okay.
and this is a 2-year. Okay. And has court complied with the court rule?
Yes, you have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 3 on the amended information will enter. Counts 1 and 2 are hereby dismissed, along with any outstanding warrants, if any, related to this file. The contraband, weapons, ammunition, whatever was seized as contraband is hereby forfeited. And do we have a sentencing date?
March 11th at 10:30.
That be with your schedule, council.
Yes, Your Honor.
Sir, you need to go to probation. You can call them. We've got a purple sheet I think they're gonna give you that has the date on it of March 11th at 10:30. However, it also has probation's phone number. It's 483-6100. However, sometimes they can be difficult to reach. So while you're in the building, if you go downstairs and make that appointment and keep it, it'd be great. We have to do a pre-sentence investigation report. I can't proceed with sentencing without it. If you fail to keep that or make that appointment, then bench warrant issues and you'll sit in jail and they'll take their sweet time to come see you. So please keep that appointment. If you want to shorten your probation period, I would suggest between now and then, or you take a weapon safety class.
Okay. Is that something that I can just sign up for?
You can sign up for it online, and council, you can talk to them about how that happens. I just need a snapshot of completion, but that certainly would make a difference to me.
Sure. And just so that we have a clear record, this would be some sort of, I mean, my client now has a felony conviction, so this would be some sort of course that does not involve the
Yes.
handling of weapons.
Yes.
Correct.
So,
And so they have some online that are federal law compliant, okay? Because now you can't handle weapon etc., but they do have a number of
safety.
very, yeah, so, and then get a certificate or just take a picture of that and show that to us or try to print it out or whatever, okay?
Okay.
Okay. My conditions are continued.
Thank you, Your Honor.
Thank you.
I need something. These are mine.
You're waiting on the trains.
What happened to
on mute.
Well, sir, interference with witnesses and talking to
I'm
witnesses
not
is not
interfering.
allowed.
I'm not.
You want, here's what else we can do, is give you 93 days contempt for interfering, or for talking over me. So what is it you want me to do?
No. Sorry.
Ms. Bolden, let me know when you have those messages.
Yes, sir.
Council, would you like to take a look at them before I do?
I was gonna ask their approach to look at them together.
Well, you can go back there and look at them.
Yes, there's quite a few. This is her message. This is her. May I approach your?
You may.
Mother of the child.
All right. I was just advised by the prosecutor that this message that I'm gonna read into the record is a message that you sent, sir, to the mother of one of your children. That's what you got to say to me after all this time? Okay, Sierra, don't even trip. If you got video drop it, then I know there ain't no video of me doing shit with no nigga, because I'm not no fucking fag nigga. I ain't never did no weird gay shit. I don't play like that. And you know it. Stop listening to stupid shit, bro. I'm your, I don't know what BD stands for.
Baby daddy.
Oh, baby daddy. Okay, thank you. You know me, Z. What the fuck is wrong with you? And why the fuck would I admit to something I didn't do? Are you okay with my nigga? I'm trying to get back to you all. You playing games, writing that shit to me. I've been proclaiming my innocence from the jump. The most damaging thing that they have is that bogus ass statement you and your friend made while you planned. You need to go talk to my lawyer and tell that nigga the truth, because you know I was never at your house the day that shit happened, and you know I never told you I did shit. I still can't believe you got mad enough to try to ruin me because we got into an argument. You supposed to rock with me no matter what, my nigga, that shit crazy to me. Who out there speaking on me? I'm confused how you could believe just anybody give me your number and we talk over the phone and I can clear up anything you want to know. I'm not about to argue with you and call you out and call out your name, or say no disrespectful shit to you, I don't move, why me, they, and you know it, so say what you want, believe what you want, you know what's up with me. I love you, Sierra, and I actually miss you and my kids more than anything. That nigga Rico was here. He was up in the feds telling people all that shit that happened that one day. When I caught y'all, one of my homeboys came and told me, so I had to check into that nigga. He tried to act tough, but he know what's up. So if you listening to that weird ass nigga or talking to him, you should know that nigga a bitch. Oh yeah, and you know I love that fat cat. So stop it. Don't blame me for no weak performances. My nigga, when you know that monkey good, as if I wish I could get a redo so I can make it up to you. That shit ain't have nothing to do with you. I love that coochie, and you know it. Every time I came to see the kids, I was trying to get some from you, but you wasn't having it. And a lifelong disease is crazy. They check you for everything when you come to the jail, and I don't have no diseases. So I'm sorry to disappoint you, but whoever you're talking to, lying, bro. Tell my kids I love them, please give me your number so I can call. I would love to talk with them. And you, even though you're trying to talk spicy to me, I don't care. I love you still. I've been gone too long to want to beef with you, Sierra, so chill on me. You can ask me whatever. I'm gonna tell you the truth. Stop writing me talking crazy about this case. You can say whatever you want about anything else. Is there something else?
Your Honor, she's a witness in the matter. She's the one that, she and her friend were the ones that called 911 when he was fleeing from the police. He was at her house. Caught running from her house. He's there asking for a phone number. He's making phone calls despite the orders of the court. There's more messages in there asking for other people's phone numbers, making calls, where's the money? I need some money to make phone calls. So I don't know what he's trying to get at here. It seems like it doesn't matter. He's gonna do whatever he wants to do anyway.
Your Honor, he's in jail, he's isolated from everybody. You know this, and I understand the no contact for, witnesses in this case, and I would certainly prefer my client not to be reaching out to her. But what we're asking for is contact with his mother at the very least.
Is his mother a witness?
His mother's a witness. She was there with a co-defendant. She's on the witness list.
Okay, there's no contact with witnesses. In any way, shape, or form, so ruling stands. Thank you.
Thank you, Your Honor.
Okay, Mr. Palmer, are you ready?
Yes, Your Honor.
And
We're doing Duncan first or the other one?
all right, and before we do anything, I want to just make a record on Wilson.
Oh, you want me to go back? We're going back on.
No, this is not just about 2 cases that are listed, but. Just want to make a record.
Let me pull that
So you
case up on my computer.
Which record are we?
Wilson. It's at the bottom of page 1 and top of page 2, and then we're gonna do Mr. Phillips' case.
Okay, I'm ready.
This is docket 20-57 FH and also 20-62 FH, People's State of Michigan versus Lee Melvin Wilson. It's come to the court's attention that these 2 cases were inadvertently opened. They were from 2020, inadvertently opened by a clerk, as far as I understand it, for no apparent reason. He is deceased. One of the cases was nollied, so it was dismissed, and we were waiting on a nollie for the other. So The reason those are coming off is because he certainly can't appear. He's dealing with the higher court. Now, Mr. Palmer, may we deal with Dashi?
Yes, Your Honor, that's fine.
Okay, let me.
Yes, I got it.
Switch this.
This would be Duncan, is page 2, second one, the 9:30.
I still need a minute. I still need a minute.
Yeah, that's fine.
So this is which one?
Shy Duncan.
Oh, yeah.
Oh, I'm just reading it here. Are
Oh.
we ready?
I think we're ready.
All right, this is docket 24689 FH, People's State of Michigan versus Dashi Duncan. Counsel, your appearances for the record.
Good morning, Your Honor. AP Burt Buxton on behalf of the people of the state of Michigan.
And good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Tashai Duncan, who is not present this morning. I can provide the court an update.
All right, well, let me just try it and then you fix it. We had a meeting back on a number of things and we included this case. It's my understanding that he is near homelessness, has no ability to come here and is having some difficulty. Counsel talked to him today. I have granted counsel until February 28th at noon, which is next Wednesday by noon. I'm sorry, January, sorry. January 28th at noon, for him to appear. If he fails to appear on that day, then a bench warrant will issue. I have a number of no shows that I was looking at on my file, including October 8th, 2025. And he had failed to appear many times prior. He was then again arraigned December 3rd. He was given, and that was 2025, was given credit for 9 days, and then he was told to appear today. He's not appeared, but apparently he's having some difficulty. I am encouraged that he did reach out to you, Mr. Palmer, or you reached out to him and somehow you two communicated. So he's got a week extension by the grace of my courtesy to you. Make it clear to him that if he is having problems, I have a great residence in Mason for him.
Yes, ma'am. I have already advised him of that. So,
Any
yes.
further record you would like to make?
Nope, that's it.
Great, thank you. Can we go on to the next page?
Yes, ma'am.
Okay, give me a second.
Yeah, no, you come on, you just stand right here. Magula? Magola. That's Magola.
Oh, I see.
Got it.
This is docket, oh, I'm sorry, Nancy, you ready?
Go ahead.
This is docket 25-3448 FH, People of the State of Michigan versus John Magola. Counsel, your appearances.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of John Magola, the gentleman who stands to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. Record should reflect that Mr. Palmer has graciously appeared here when Ms. Amanda Tringle has again failed to appear, although I understand she may be ill. Mr. Palmer, what are we doing here today? This is a date for a final criminal pretrial conference. We do have trial jury selection on Friday.
That's correct, Judge. At this point, I anticipate that we are pushing forward towards trial. I have had an opportunity, I've spent, I don't know, maybe an hour discussing this matter with Mr. Magola, and if I may, I'm just going to make a clean record. There was a plea offer extended to him. That offer was improper transport of a loaded firearm in a vehicle, that being a high court misdemeanor, 2-year high court misdemeanor. I've discussed that with Mr. Magola. He has had an opportunity to consider his options in this case, in this matter. I think that the issue at this point is that Mr. Magola is interested in maintaining his Second Amendment rights, and the plea offer that has been extended to him would prevent him from doing so. And so with essentially no criminal history for him, I think that the issue now is that he's really no better off going to taking a plea than he is just going to trial and sort of rolling the dice, so to speak. I've not, because I just met him an hour ago, I've not had an opportunity to run guidelines, but my anticipation would be that his guidelines are going to be presumptive probation on a file like that. So I don't know that he's any better off taking a plea. Taking a plea to a reduced charge, which still essentially violates his gun rights. I don't think he's any better off that way. Even with the Killebrew for no upfront jail than it is going to trial. Nonetheless, I will just say I have discussed all of his options with Mr. Magola. I've explained to him that it is his choice and his choice alone. And my understanding, and I can ask him on the record, but my understanding is that at this time he is electing to proceed to trial.
Is that correct?
Yes, it is.
And you understand that we'll go to trial on Friday now. I don't do this often, but if you do talk to Mr. Dwayne, the plea offer gets better, we can deal with that tomorrow. I do have some limited time that I'm on the record tomorrow. I can certainly deal with a plea tomorrow. Otherwise, sir, you're going to trial. Did anyone force, threaten, or coerce you to make this decision?
No.
Anyone promise you anything that caused you to make this decision?
No.
And you've been satisfied, although Mr. Palmer's stepping in, you're satisfied with his representation?
Yes.
And you'll be ready for trial on Friday?
Yes.
On behalf of the people, anything further?
No, Your Honor, I would agree that that is the plea offer. I would also agree that there was a Killebrew to no upfront jail at the time of sentencing. And we will be prepared to go to trial on Friday.
Judge, I guess I'll just place this on the record because I'm not sure what's going to happen. My understanding is that Mr. Magola's counsel of record, Amanda Tringle, is out ill today, may have the flu. And nonetheless, she's not available. She has an illness which prevents her from being here today. And I was asked last night after hours to step in and handle this final pretrial this morning, which I've done. I don't know the status of Ms. Tringle's illness, and obviously I don't know whether she will be prepared to proceed to trial on Friday. I will say this, It seems like a relatively straightforward case, and I would be happy to try it on Mr. Magola's behalf. My only concern is that I am scheduled for an AWIM prelim with co-defendants at 8:30 on Friday morning for Judge Buchanan. I suspect that may get adjourned because we're still missing some discovery, but I guess I would say that someone from my office, if Ms. Tringle is for some reason unavailable, someone from my office will be here. I will talk to Mr. Cornish this afternoon about a number of matters, but this will be one of them.
Well, let me say this. Ms. Tringle has a habit of not appearing before this court. So Friday, you certainly can be first chair or second chair if she decides to show up. I do have some empathy for someone being sick, but this is more of a bad habit. So, and this is not a very complicated case from my understanding. Furthermore, the preliminary examination, certainly you can do that and then head over here. It's my experience with juries, they're called in about 8. Usually about 9, we call them. By the time they all get up here, it's usually 9:30 or 10 o'clock. I don't think you're going to have an all-day prelim on that matter. So we'll wait for you.
I don't anticipate that we would have an all-day prelim by any means. Yes, there's a number of things up in the air, I guess, about that case. So I just don't know how that's going to proceed at this point. I guess that's what I'm saying.
And I'm saying it's not going to delay this case. And if for some reason it does, we can have a jury on Monday. This is not going to be probably even a week-long case. So,
Judge, I would anticipate that it'll take us longer to pick a jury than it will to try the actual case.
agreed. And sir, I certainly understand you wanting to go to the jury. I don't know much about this case, but in the end, it looks like you'll probably have the same outcome whether you plead or go to trial. I certainly understand that. I don't know if the offer is going to get better or not. But it looks like you don't have much of a criminal record. So regardless of what happens, you should be able to get, as long as things go well in the next few years, you should be able to get set aside.
Okay.
So I certainly understand your choice and it is your right to go to trial. So what I would do regardless, our prosecutor, for good reasons, has a zero tolerance for weapons. So you're kind of slamming up against that. I don't speak for him. I don't know what he's going to do. But I would, because of knowing that, I would prepare for trial with your attorneys. So I'll see you Friday, and if there is some great offer you're willing to take, then we'll see you tomorrow. Is that all right?
Okay.
You need to stay in contact with Mr. Palmer.
Okay.
Did you have a question?
I just, when you said a set aside, I just didn't know what you meant.
There's a set aside means that you'll earn a non-public record by staying clean for 5 or 7 years, depending on what it is. If you stay clean, then it would be set aside by the court.
That's the same thing. I didn't use the language set aside, but that's the same thing you and I were talking about how you have to wait a period of 5 years. It's the same. That's what she's referring to. She's just using different language.
Yeah. We have a couple of them coming up today, actually. If you stick around the court, you'll be able to watch them. But nonetheless, you don't, yours is probably the cleanest record I'm gonna have in a month.
I would agree.
So I certainly understand, and there's jury nullification, so and I don't know anything about what happened here, it didn't happen, so I certainly understand it, and if you want to go to trial, that's your right, and I'm here. Okay? And if there's a conflict with your attorney, then I can always send the jury home and you can do it Monday,
And
so.
then what?
If there's conflict with the trial, in terms of your client being over in the other court, we certainly can do it on Monday. So make sure your Friday and Monday are free regardless, okay? All right, bond and bond conditions will continue, that's all.
Thank you, Judge.
Thank you. We have 3 Thomases on our docket today. On the front page.
There should be two for Rayshawn Thomas.
There's two files, but there's two other Thomases on the document.
Right. Oh, what? This one,
I know.
this one has Mr. Mataloni, but Mr. Mataloni withdrew, and then he decided he wanted to represent himself, so he had a standby counsel tonight.
You just stand by.
But I don't remember who that was.
And I don't know either, so if we want to wait, I don't know if we want to.
All right, this is docket 23-845 FH and 23-842 FH, People of the State of Michigan versus Rayshawn Thomas II. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of people of the state of Michigan.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, you previously had Mr. Mataloni representing you, and then you decided to release him and represent yourself. And I also ordered that there would be standby counsel for you, advisory counsel, because you didn't go to law school, just to protect your rights and make sure everything goes well. Was there an attorney who ever contacted you?
No, ma'am.
Okay, well, we need to figure out why that fell through the cracks. All right, what are we doing here today?
Your Honor, today is the final pretrial. The plea offer is the same as it has been the last couple of times, Your Honor, where the defendant would be pleading in 23-842-FH to count 1, home invasion, and count 2, felony firearm. We would be dismissing count 3 through 8 as a result of that plea, as well as 23-845-FH in its entirety. My understanding is that Mr. Thomas has rejected that plea on numerous occasions, but just so it is on the record, that offer is being put on the record again.
I think counsel, and maybe I've got it. Let me just make sure it's right. Oh, no, it's right. Okay, so 842. All right, so sir, did you understand that plea offer?
Yes.
And regardless of whether or not you represent yourself or you have standby, would you like to talk to counsel?
Yes.
Okay, so would you like me to now appoint you counsel?
Yeah.
Okay, so we're gonna appoint you counsel, not just standby. You have to change your mind about representing yourself?
Yes, ma'am.
All right, and I think that, my notes, and they could be incorrect, but my notes indicate that if you're convicted on this file, the guidelines run from 84 to 140 months, which is 7 years to 11.5 years. However, under the plea agreement, it would be 78 to 162 months. So that would be 6.5 years to 13.5 years. That doesn't make sense.
Those are the guidelines that I have written down in the file as well, Your Honor.
So a half a year shaved off, but it's extended on the end?
I believe it's the opposite way, Your Honor. I believe it's, if he was convicted, it would be 78 to 162, but under the plea, it would be a higher minimum, but it would be a lower, high end of guidelines, it'd be 140. So I believe it's the opposite, the other way around.
If he's convicted, it would be up to 140.
If he was convicted, it'd be 162, Your Honor,
Okay.
because of the habitual, I
Okay,
believe.
so if he takes the plea, it would be 140?
It would be 140, yes.
Okay, so
That is my
essentially, the plea is shaving off 2 years on the minimum.
The
I'm
2 years
sorry,
are
on the
maximum.
maximum, sorry, yeah. We've been on the record so many times on this, my notes are a little unclear. All right, so we're gonna get you an attorney. I'm gonna have you come back. Do we have a trial date on this?
It is set for February 27th, Your Honor.
All right, February 25th at 11:30. And that's going to be for a continued final pretrial and to meet with council, we'll see what council says. I don't know that they'll be ready to go to trial on all this, but we'll get new dates at that time and see what they have to say.
That's fine.
All right,
Thank you, Your Honor.
thank you. All for that record?
You know, that transcript in there. So nice, thank you.
The next matter.
He's the only one still here, so.
What happened on McDonald? Did we just do that?
We did play on that.
That was. Okay, what's about Nance?
Yes, we get on the
that's
record already.
on the record. Okay, so what about KISS?
I have not seen anyone from the public defender's office on KISS. It was Edward Hess previously, and I'm not sure if they reassigned someone or.
Has he been brought over?
I doubt it. This is the 2019, so it's one of those old ones.
Is he in custody or is he in benchmark status? Do we know?
I don't believe he's in custody, Your Honor. He's not here at the very least, I can tell you that.
Okay.
I think the satisfied, she was on.
I do
Hang on a
see-
second.
I do see some. Yeah, one of that's outside.
Okay, let me look at the 9 o'clock KISS. Nobody appeared, is that correct?
Yes, Your Honor.
All right, this is docket 19. 514 FH, people of the state of Michigan versus Trey KISS. This is set for a status conference. No one has appeared. We'll have to deal with the public defender's office to see where they were. But also, defendant has not appeared, so bench warrant bond forfeiture.
Thank you, Your Honor.
Oh, wait a minute. We must have already had grants, no?
It might have went to Canada, it might have been one of Judge Kennedy's, they got kicked back to us after that, I don't.
Which one?
100% remember.
KISS.
What I think happened is it went to the Court of Appeals and the Court of Appeals reversed and then for whatever reason didn't make its way back on the docket afterwards.
This is one of those old, this is the 2019 case.
So was he noticed about today or not?
I know that the PD's office had received notice, Your Honor, because I was included in that email.
Okay,
I believe, let me double check.
well, bench warrant bond forfeiture. Okay. And if the people could get hold of the victim to see if she is going to,
And I did, Your Honor, and I have had a chance to talk to her.
so did you actually reached her?
I actually did reach her, Your Honor, I talked to her yesterday.
Okay,
Are we doing Lattimore? The 9:30 Lattimore? Or is that up?
I know what happened to Lattimore.
This is Simpson, Your Honor, we're ready.
We're ready to go, Your Honor.
Okay. This is, Nancy, are you ready?
No, I gotta do one today. I'm ready now, sorry.
Ready? This is docket 25-4208 FH, People of the State of Michigan versus Narion Darrell Lattimore. Counsel, your appearance for the record.
Good morning, Your Honor. APA Burt Buxton on behalf of the people of the state of Michigan.
And thank you, Your Honor, and good morning, Jared Austin, appearing on behalf of Mr. Lattimore. He does stand present to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
You put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with Mr. Austin?
Yes, Your Honor.
Have you reviewed the pre-sentence investigation report?
Yes, Your Honor.
On behalf of the people, any correction, addition, deletion?
No, Your Honor.
On behalf of the defendant?
I have none, Your Honor.
All right. Sir, just as a reminder, you pled no contest to count 2, domestic violence, a 93-day misdemeanor, and count 3, assault with intent to do great bodily harm less than murder or by strangulation, an attempt, so it's half of what it would be, so it's 5 years. You also pled no contest to that. Do you recall that?
Yes, sir.
All right. And as to the guidelines, any corrections?
No, Your Honor.
We have no challenges to the scoring of the guidelines, Your Honor.
Thank you. Do we have a victim here?
So, Your Honor, we do not have a victim here. However, I have received a victim impact statement this morning. I don't know if you would prefer me to approach or read it to you.
Why don't you read it for the record?
Okay,
Nice and slow.
will do. Regarding victim impact statement number 25-004208 FH-C30. I would like to thank the court for allowing me the opportunity to provide a statement in this matter. These thoughts are shared sincerely and with intention. They are not offered to excuse, minimize, or justify any behavior that occurred on July 14, 2025, but rather to acknowledge my role, accept responsibility for my actions, and express my hope for growth and healing moving forward. I understand the seriousness of the circumstances before the court, and I respect the state's responsibility to intervene to ensure the safety and well-being of all involved. I also recognize the court's duty to protect those interests. My desire is aligned with the same goal: the safety, stability, and long-term well-being of my family, especially the children affected by this situation. I can only speak for myself. I take full responsibility for my actions and for the steps I must take to ensure I am never in this position again. I am committed to doing the necessary work to grow, to heal, and to minimize the negative impact of this incident on everyone involved, particularly my stepchildren, Naziah and Aiden, and my son, RJ. Although this incident did not occur in front of the children, their lives were affected immediately and significantly, and I wish to advocate for their emotional well-being and futures as well. To provide context, not as an excuse, I want to share where I was mentally and emotionally leading up to July 14th of 2025. In 2024, I had experienced the loss of 3 grandparents within a 6-month period, which resulted in the loss of much of my family support system. During that same year, I lost my driver's license due to traffic violations, and shortly after, my only means of transportation was repossessed. These events occurred between May and October of 2024 and led to significant emotional distress. As a result, I took a medical leave from work and was under a doctor's care while attending regular therapy. I was diagnosed with severe depression, anxiety, and PTSD, conditions I had struggled with earlier in life, but had managed independently for many years. I reached the point where I could no longer do without professional help and sought that assistance. I returned to my employer in January of 2025, but shortly thereafter, my family was notified that our rental property was being sold, requiring us to move within 60 days. This was our 3rd move since relocating to Michigan in 2022 and created substantial financial and emotional strain. On May 13th of 2025, I was unexpectedly laid off due to a company acquisition just weeks before a required move. This resulted in the loss of my long-term income, health insurance, and access to ongoing medical and therapeutic care. I experienced a delay in receiving unemployment benefits and became fully dependent on others for support. For the first time since I was a teenager, I was unable to provide for myself or the children in my care. This deeply affected my mental health and sense of stability. By July, I was emotionally overwhelmed and not exercising the judgment or self-control I am responsible for maintaining. I acknowledge that Marion, like myself, has areas where growth and accountability are necessary. I also believe he has demonstrated the ability to comply with in-state and out-of-state court requirements while prioritizing his responsibility as a parent through the years of our marriage since winning and maintaining custody of Neziah and Aiden in December of 2022. Based on my experience and knowledge, I believe he is capable of successfully completing a sentence of probation and benefiting from continued structure, accountability, and access to appropriate resources while remaining present for his children. My request to the court is made with humility and respect, and I ask that consideration be given to a sentence that emphasizes accountability, rehabilitation, and stability, rather than one that would create further disruption in our children's lives. I believe probation would allow for growth, compliance, and continued parental involvement for both parties while maintaining the safety and oversight required by the court. The events of July 14th of 2025 represent the darkest moment of our marriage and the moment the court was introduced to us. I deeply regret my actions and accept responsibility for my role in what occurred. I respectfully ask that the court consider who we are beyond that day and allow the opportunity for demonstrated accountability, growth, and change for both Marion and me. Thank you, Your Honor, for the time, consideration, and care given in this matter. Respectfully, Amber Lattimore.
Thank you. On behalf of the people, what would you like me to know?
Yes, Your Honor, as you heard from that victim impact statement, the victim would be on board with this recommendation of 12 months probation. I believe that this 12 months probation would be good for the defendant in this matter, to deal with any domestic violence issues he may have, but ensure that he is still allowed to be in his children's lives. Thank you.
Thank you, counsel.
Thank you, Your Honor. Ultimately, I believe the recommendation of probation is appropriate. That's what I'm going to ask the court to adopt and follow. And just echoing some of the statements in that victim impact statement from Mrs. Lattimore, there's been a consistency in her statements and what she stated here, and as well as what she initially told the police on the night of this offense, is that she has consistently stated, separate and apart from what happened between her and Mr. Lattimore, is that he is a good father to his children. And the children that he has are not with the victim in this case. He was granted full custody of those children from the Indiana Family Court. He was given special permission to be able to travel there on bond in order to comply with that family court's orders. And I think that speaks very highly of Mr. Lattimore, that they gave him not just joint custody, but full custody of his children. He's working. He has a lot of stability in his life. His prior criminal history is rather sparse. It's consisting of misdemeanors. All of his prior misdemeanor convictions are, one, several years old, and two, they're all nonviolent in nature. Since this case has been bound over from the district court, he has not been found to be in violation of any of his bond conditions or the no contact order, nor has there been any allegation of such since this case has been bound over from the district court. Mr. Lattimore has resolved his case, and I believe is fully willing to abide by any and all court's directives and orders, which he's already demonstrated that he can and will do. And I don't have any reason to believe that will do anything but continue during a term of probation. I certainly think he's demonstrated he's capable of being rehabilitated, and I think probation will allow him the opportunity to do that And that's what I would ask the court to do, and I would ask the court to adopt and follow the recommendation and not to exceed what is being recommended. Thank you.
Is there any restitution being sought?
There is not, Your Honor.
Sir, what would you like me to know?
The only statement that I would like to make is that I'm extremely remorseful for my actions. I do understand it's a very severe charge, and I do understand my actions and of that day. I understand the impactfulness on my children.
I understand the impact.
And the impact, sorry, on my children, and the impact that this will have on me going forward, regardless of what I'm sentenced to. I'm sorry, I'm a bit taken aback from this because this is my first ever thing hearing from my wife in a while. So I'm just a bit taken aback. Sorry, I'm a little
It's
emotional.
okay.
I do, I miss my family a lot, and this has affected us a lot, and I would love to be able to heal from this and go forward and reconcile with my wife and bring my family back together, because this instance does not describe who I am as a man or my character at all. As my wife stated, this was the darkest moment of our marriage, and it's unfortunate that this is how we were introduced to the court system, but this action does not reflect who I am or who we've been over the past of our marriage.
Mr. Ring, would you please obtain the copy of the impact statement and provide a copy to the court, counsel, and defendant? So, sir, it's your intention to remain married to your wife,
Yes, Your Honor.
and is she the mother of your children?
No, Your Honor. But I would like the court to know that she has been the sole, pretty much everything but their blood mother since 2019. I did receive custody of them in 2022. Before that, they had frequent visits with me and with Amber. She's been there for them just like a mother, and she's been there for them more than their own mother. So other than blood relation, I would say yes, that is their mother.
And so the kids are living with you.
Yes.
So let me just tell you what concerns me. So you and I can have a chat, okay?
Okay.
This pre-sentence investigation report acknowledges, as you did when you pled, and as she has as well, that this was a domestic dispute between you and your wife. She was reluctant to speak to law enforcement, but she did because of the children. So that is a true mom. She treats them, as you said, like her own. She advised that the instant offense was not the first time she had been assaulted by a defendant, and that she did not report the previous incidents. A witness stated that she observed defendant assaulting, choking the victim, and that the assault ended when the witness advised she had called the police. Officers noted visible injuries to the victim's arms and chest area. However, she refused medical attention. So I don't know what's going on in your marriage, but it appears to be volatile for one reason or another. Let me make it clear. If you don't do well in this probation, I will call protective services. I do not know where your children will land, but you will land in jail or prison. I take this very seriously. When these things happen, especially in front of children, even if you think the children are not listening, they are listening. And that is emotional trauma to them. So I'm going to put you on probation for 12 months. I'm going to require that you do the long-term domestic violence program. Now, they recommended the online one. I don't know if it's that one or do you do the one at Pat's where you actually attend. But I'm also going to,
I'm sorry.
so you can figure that out with probation. And
Well,
your
I already started. Remember last time we were here, you told me, you suggested I get in before this.
So did
I've
you
already-
start it?
Yes, ma'am. I paid for it's like an online class thing. They recommended me to do
Okay.
go a long 52-hour course. I emailed that,
Have you completed it?
no, ma'am, I just started. I am 14% through. I've been doing it since I enrolled in December. I
Okay,
showed that to the PSI, a woman as well, Ms. Persons, and she said that that would be sufficient.
okay. So you need to complete that and follow all recommendations. As to your wife, I want the two of you, I don't know what issues you've got going on, but I want the two of you in some kind of counseling. If you're gonna repair the marriage, then let's get whatever is about trauma therapist, marriage counselor, what have you, it could be a reverend, I don't know,
Yes, ma'am. For clarity, do you mean separately or together?
together,
Yes, ma'am.
and don't have jurisdiction over her. But with what she wrote, it seems like she too wants to save the marriage. You can't save a marriage without communication. And it appears that your level of frustration goes to using your fist or your hands. So two of you need to work together, so whatever's out there that upsets either one of you, I'm sure that she has issues with you too. It's never one-sided.
Yeah.
So the two of you need to be in some kind of couples communication, healing, domestic violence therapy,
Yes, ma'am.
not online. In a meeting with a trained therapist.
Yes, ma'am.
Now, I don't know what insurance you have, if you have insurance or what have you. There are, or if you're involved in a church, but there are also some very good pastors in our community who are very well trained and hold individual and group family sort of counseling. So if that's what you want to do, and probation approves it, that's fine too.
Yes, ma'am. Just for a little bit more clarity, because she's in Indiana, is there a guideline that I should follow or is?
Well, let me ask you this. So your wife is in Indiana,
Yes, ma'am.
and are you planning to go to Indiana?
Well, I have to go to Indiana court ordered every other weekend. I don't have to go to where she is, but I do have to, I'm court ordered to take my children to Indiana every other weekend for their visitation with their mother, so.
Okay.
I am in the
So
same state, but I'm about 40, 50 miles away from where she
how
is.
are you and your wife gonna get together if she's in Indiana?
I would assume that if we were granted to communicate again with each other, that we would, once we got, granted to communicate, we would figure that part out. I do recognize this address. This is her mother's address, so I assume that she hasn't established like the real, actual, like her own place there, because this is her mother's address. So I would assume that.
Okay. I don't want you to assume, but what I'm going to do is allow you to communicate with her for counseling. Certainly, since COVID, many therapists actually do Zoom counseling.
Yes, ma'am.
So you two can start communicating through a trained therapist.
Yes, ma'am.
And for the purpose of setting this up. Now, if she doesn't want to comply, then there's a whole story there, sir, and maybe your marriage is not going to work out. And you need to be able to deal with that, because sometimes you have to set aside the love you have for someone and look at, is this genuine love or is this some kind of control and obsession kind of issue? Because the fact of the matter is, sir, if I were you, and I don't want to speak for you, I'd be worried about remaining with someone that isn't willing to go to counseling, because there's going to be triggering events by either one of you, which means you may very well land in front of a judge, or she will. And if it's you, you could very well go to prison next time. And then there's no daddy to raise your children, and you're gonna have to prioritize your life with your kids before anything.
Yes, ma'am.
So there's a whole message there if she doesn't want to go to therapy with you, and I don't have any jurisdiction to tell her, but I can't allow you to actually reside together until a trained trauma therapist, domestic violence therapist says it's safe for you two to be together, and you've both learned the communication skills needed to keep everybody safe in the house. Does that make sense to you?
Yes, ma'am.
Okay. So I will let you communicate with her in regard to children's needs. They probably want to talk to her, and also in regard to counseling, nothing else.
Okay.
And then that can be expanded as the therapist recommends.
Okay.
Does that make sense to you?
Yes, ma'am.
You'll be on probation for the 12 months. That can be decreased or increased depending on how well or how poorly you do. You will not use, possess, consume, or be in the presence of any alcohol, marijuana, any other illegal substances. And so if you have the need for alcohol or marijuana, you'll need a prescription from a licensed medical physician and present that within 24 hours. All over-the-counter medication you'll take as labeled in the bottle. You can take less but not more. If you get prescriptions, you'll use them as labeled and you'll provide us a copy of the prescription within 24 hours. You'll not possess any controlled substances, illegal substances, or drug paraphernalia. You'll complete the domestic violence intervention program that you are enrolled in, as we've discussed, and then the couples counseling. You'll sign all necessary releases so we can verify that you're doing what you need to do. We're never going to ask what are you talking about. Just want to know, are you attending? Are you participating? Are you showing up on time? Those things. I'm following the recommendations. Those become orders of this court.
Yes,
You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not use any corporal punishment against your children. You will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections or who has a felony record. If you need to have contact with someone who is a felon, you'll need to get permission from the court first. You'll contact probation within 24 hours. I suggest you contact them as you leave the building and keep your first appointment and all subsequent appointments. You must allow probation into your residence at any time for probation supervision without a warrant and submit to a search of your vehicle, cell phone, residence, and computer. If there's reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest, police contact.
You must what?
Report any arrest, police contact, personal protection order placed on you, loss of employment or change of employment or residence or phone number to probation within 24 hours. Weekends and holidays are accepted. So if something happens on Friday, tell us on Monday. If Monday's a holiday, tell us on Tuesday. You can travel to Illinois upon notice to probation of when you're driving back and forth for your kids.
Yes, ma'am.
All right. And you will remain gainfully employed. If at any time you're unemployed, you'll be part of the work week program. You'll serve 365 days jail with credit for 3 days served. The balance of the jail is held. You'll pay a crime victims assessment amount of $130. You will pay a $118 state cost. That's $68 for each count. You can be on a payment plan for that. I'm waiving fines, costs, and attorney fees. And probation oversight. Are you able to pay your bills, sir?
Yes, ma'am.
So you'll pay probation oversight at the rate of $30 per month. And you'll comply with DNA testing if that hasn't already been done. And you'll not use any object as a weapon, no guns or ammunition, imitation of a weapon. You'll not use any object as a weapon. You have 42 days to appeal and to request appellate counsel. You acknowledge receiving your appellate rights.
Oh, yes,
All right, any questions, sir?
No, just only because I've kind of been through the ordering counsel thing part before, and it's been times where I've been told by the counselor themselves, been asked by the counselor themselves what like time length or anything like that, but the judge has ordered.
Well,
So
I don't know who the judges are, and I do know, because I was a practicing lawyer for a long time. I don't know who the judges are that give timelines on that. None of us are trained, or very few are also social workers or therapists. Shouldn't say none, because I know a few people who've run who were therapists, so I don't know if they ever won or not, but nonetheless, when your therapist says you're done, you're done. I am not trained, I'm not participating in it, and if you have someone who is a trained marriage counselor therapist who says you're done, go about your business, that's all good with me. So I don't know if it's 2 times or 20 times or 200 times, it's up to them.
Okay.
Okay,
Okay, thank you.
anything else?
I have nothing additional with Mr. Lattimore, Your Honor. Thank you.
Thank you, good luck to you, sir.
Thank you.
That was the only.
Yeah.
We're doing balance.
No.
No.
it's,
Like, that's
uh,
before.
it's Sarah Side.
This is your name, oh, okay, because it says.
Jared was the attorney.
That was many years ago.
Yeah, in twenty
What are
fourteen.
we doing next?
We have,
Balance next,
Who?
Nathan Kuajala.
Sydney Balance.
What about Romanes?
We have, I don't know, I don't think they did a writ for him.
No red, so that means do we have a new date?
I don't know, I'm just, what I heard through the grapevine, I don't know.
And I know that
This
Ms.
is
Donnelly was
about-
getting a new date, I don't know if it's been gotten yet, but I'll make sure that there is a new date.
On
before I leave the
Wormness?
courtroom. On Wormness, yes, Your Honor.
And then what about Kuajala?
Kujawa, I've not seen Attorney Shepherd on that case just yet.
Well, it's 12:15.
I'm aware, Your Honor.
Is the defendant here? Mr. Kujawa, are you here?
Go check out in the hallway, Your Honor, one moment. I just called out in the hallway, and did not get a response.
All right, we're gonna do Kujawa next.
What time is that at?
At 10.
Oh, here we go.
This is docket 22-670 FC, People of the State of Michigan versus Nathan Andrew Kujawa. This was set for 10 o'clock. It is now about 20 after 12, and I have no attorney and I have no defendant. This case is rather old. There had been a motion to quash and dismiss, which the court denied. And that was in, I can't tell you the exact date, but that was in 2022, I think. It was a while back. Nonetheless, what remains on this, there were a couple of counts that were dismissed by the people at preliminary examination. That includes counts 1 and 3. However, count 2, criminal sexual conduct, assault with intent to commit sexual penetration remains. Count 4, criminal sexual conduct 3rd degree, multiple variables remains. Kidnapping, count 5 remains. Count 6, criminal sexual conduct 3rd degree remains. The officer has indicated he is not in lockup. He is not on Zoom. He is not in the hallway. And when I say he, I'm referring to defendant. Therefore, bench warrant bond forfeiture. It appears this case is rather old. I don't know why he's not here, but it's not acceptable. And it looks like we have regularly had them in front of this court. In fact, witness lists were filed and received May 9th, 2023. So I don't know why this hasn't gone to trial. I suspect he's been AWOL. The last address I have is 911 Malon, Mahlon Street, Lansing 48906. And he had a roommate. So I made the record. We were supposed to have the trial April 21st. I don't know why we didn't have it, but nonetheless, bench warrant bond forfeiture. This case needs to move forward. Anything else for the record by anybody?
No, Your Honor, thank you.
Thank you.
Which one we doing first?
Mark called balance earlier, so we'll do it first.
Oh, balance is gonna go next.
I don't know if anybody's here for it.
All right. This is, are you ready, Nancy? Texas docket. Docket 14-578FH, people of the state of Michigan versus Sydney Balance. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Barb Bucks on behalf of the state of Michigan.
Rebecca Nybert, serving on behalf of Legal Services of South Central Michigan and Sydney Balance.
I did any of that. All right, counsel, there was a blip and we did not hear your name. It's Rebecca.
Yes,
And your last name?
Nybert, Nighbert, Your Honor.
Thank you. And we have Ms. Balance.
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do, Your Honor.
Thank you. You may put your hand down. So I see on your, are you married now? You have a different name?
Oh, I'm sorry. That's my middle name. That
Oh, okay.
I
just wondered.
apologize
That's
for
okay.
that.
Oh, no, it's not a problem. I respect that. I just wanted to make sure if you had a different name that the paperwork went to the right place and everything was done properly, so.
No, it was
All
a
right,
mistake in my autofill. I apologize. It did it automatically when I signed in.
Not a problem. All right, on behalf of the people, is there any objection? Are you in receipt of everything you need to review?
And that's my concern, Your Honor. I have not received the report from the Michigan State Police or the letter from the Attorney General at this point.
I do have the Attorney General letter.
If I could approach, Your Honor, and get a copy. Your Honor, I have the receipt of the letter from your staff. It appears as if the Attorney General believes that she may be eligible under statute as long as the post-conviction circumstances and behavior warrant setting aside a conviction. At this point in time, Your Honor, the people would have leave in court discretion.
Thank you. On behalf of your client, what would you like me to know?
Your Honor, my client would actually like to speak to you directly if that's okay.
Absolutely. Ma'am, what would you like me to know? What did you learn from this?
Oh, I've learned a lot. I've done a lot of growing and healing. I made some mistakes in the younger years of my life. And I do not believe that reflects my character in any way. It's not something that I believe was of morale. So I take responsibility for the mistakes I've made. And I have not, committed crimes or had a record in quite a long time. I do not plan on doing such things. I've been doing very good with my life. I'm working very hard to get more time with my children and focus on being a mother and healing from a lot of things that I've been through in life. And I'm very proud of myself. I'm making moves to set up a good future for myself and my children. And I'm doing anything necessary to do that. I'm educating myself. I'm making moves to buy a home, to set them up with life insurance and trust funds, and all of these things that I was not taught by my own family. I'm trying to teach myself so that way my children hopefully don't have to experience the things that I.
All right, thank you very much. Appreciate that. All right, well, an application. An application to set aside the following conviction was filed on October 21st, 2025. Controlled substance delivery, manufacture of controlled substance less than 50 grams. The date of conviction was December 3rd, 2014. The Michigan State Police has reported the required information from its records. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assault of crime set aside pursuant to the statute during their lifetime. There are no criminal charges pending against the applicant. The applicant has not been convicted of any criminal offense during the applicable time period required under the statute, and the applicant is requesting that a felony offense punishable by more than 10 years imprisonment be set aside, and has not previously had felony conviction for the same offense set aside pursuant to the statute. The time period required by the statute for the convictions listed has passed, and an opportunity has been given to the Michigan State Police, the Attorney General, and prosecuting official to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. Therefore, the application is granted as to the conviction listed in item 1, and pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. Ma'am, if you were here, I would be shaking your hand and giving you your order, but so I'm doing it virtually. We're going to send a copy of this to you and your attorney, and this will get filed. Now, counsel, if this remains open after about 4 weeks, let me know so I can make a phone call. They're much quicker at it since they were behind in COVID. I think they're all caught up. So the last order of this court, ma'am, is that you go out and celebrate with your loved ones. Okay, this is a really victorious day, and I applaud you. Thank you.
Thank you so much. I can't thank you. Have a beautiful day.
You too. Thank you. That is all for the record.
Thank you, Your Honor.
All right. I understand we need to go back on the record on Mr. Kajawa.
Okay, hold on.
You had the AG letter on the other one?
That's an AG case, so I don't have anything on that one. I think that's the AG would be doing that case, not us.
All right, back on docket 22670 FC, Hill State, Michigan versus Nathan Kajawa. I've just been informed by my staff, I don't know how it got him or stayed on my schedule. Well, apparently we have, there was a pre-trial or some negotiation that was held, and what was signed by counsel and the prosecutor was then signed by this court on November 19th, 2025. And this is scheduled for a final pretrial May 13th and a jury trial June 5th, 2026. I don't know why this ancient case needs this much time. This will not be delayed again. And if it looks like we're going to trial, I would ask people to watch this and let's set it for a trial earlier. So the bench warrant is recalled. All right,
Is that it on
bond reinstatement? Yes, thank you. Now we have one more set aside.
Yes.
Hold on.
Mr. Green, are you here on something?
Waiting for Barb.
It's at 1 o'clock.
Oh, you got a 1
I have
o'clock.
3 jobs at once.
Okay. This is docket 18-340 FH. People of the state of Michigan versus Marie Denard. Counsel, your appearance for the record. Is there anyone here on this?
I think she was on Zoom.
She's on Zoom.
Ms. Denard?
Yes, I'm here.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right, you may put your hand down. I understand this was an attorney general case. I have a letter from the attorney general, Michael Ajami, assistant attorney general, and he's with the expungement division. And it says that you may be eligible, and as long as the court agrees they're in agreement, necessary documents have been provided to the court. Ma'am, what have you been doing since this case happened?
Well, I've been working on myself. I'm currently in school right now. Throughout this last 5-year journey, it has actually led me to me being in school and kind of narrowing down what I want to do in life. So it kind of came full circle as far as trying to get a job with this particular felony. Being in the healthcare industry has been difficult navigating through that, but I have managed to stay employed relatively most of the time. Starting off with my first employer that gave me a chance at the urgent care a little bit before COVID time. I stayed there for a while, and then that contract, I'm sorry, had ended. Still trying to navigate school, trying to narrow down what I want to do. So currently, I have settled on a major in criminal justice, minor in psychology, and now I'm trying to hopefully get into my doctoral program for forensics psychology. So with this expungement, would definitely help me attain licensures down the road once I get into my doctoral program. Um, Currently, that's what I'm doing right now. I'm taking classes. I'm actually in a victims advocate class currently as we speak, hoping to get an internship at the courthouse to once again strengthen my application for school. So I've really been doing the work, more so changing my mindset, fully take responsibility on my actions as being the sole owner of that business at the time, and just looking forward to a future and helping other people.
So some of the best therapists, lawyers, police officers, psychologists, all those, the things that you're looking at, and you're working toward and going to school for, some of the best ones who I know have a history. And so they really relate with clients and the people that they're dealing with because they've been there. So I appreciate that you are going into a number of different areas where you will be able to relate to people very well because you've been there, you've been through the process. So I appreciate everything you've done, and I'm going to grant you your request. And an application.
Really appreciate that. That means more than you know at this time.
Now, let me just see, do you know, I don't have what date you filed this, I've got to put that on this. My law clerk was gonna get that. So an application to set aside the following conviction was previously filed in compliance with the statute. False pretenses less than $20,000, and the date of conviction was July 30th, 2018. The court finds the Michigan State Police have reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assault or crime set aside under the statute during their lifetime, and there are no criminal charges pending against the applicant. The applicant has not been convicted of any criminal offense during the applicable time period required under the statute, and the applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute. The time period required by the statute for the conviction has passed, and an opportunity has been given to the state police, attorney general, and prosecuting official to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the applicant more than warrant and justify setting aside the convictions, and it is consistent with justice and public welfare. Therefore, ma'am, your application is granted as to the conviction listed in item 1.
Mhm.
And pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law.
Okay.
This order has been read, dated, and signed in open court. And ma'am, we're gonna get you a copy of this, and probably, I wanna say not more than 4 weeks, but if you find it, it's not non-public, it's still public, let my office know so I can make a phone call, all right? Last order of this court is always go out and celebrate with your loved ones.
Thank you. I will.
Congratulations, if you were here, I'd be shaking your hand and giving you your order, but